Can I request everyone to please take their seats? We'll be starting with the next session very soon. The next session is hosted by Gandhi Law Associates on Guerrilla tactics in Indian arbitration. I would like to invite on stage the panelists and the speakers for this session. We have Mr. Kunal Vyas, partner at Gandhi Law Associates, who will be moderating the session. We have Justice Akil Kureshi, former Chief Justice of Rajasthan High Court and former Chief Justice of Tripura High Court. We have Dr. Rishab Gupta, advocate at Bombay High Court and barrister at 20 Essex. Ms. Rashna Mistry, General Counsel, Tata Projects. Mr. Shiv Sharan Kaushik, Senior Vice President Contracts, Kalpataru Projects International Limited. And Ms. Scheherazade Dubash, Senior Practice Development Lawyer, International Arbitrations at Pinsent Masons.
Wishing everyone a very good morning. We are related to hosting this session. I am Kunal Vyas. I'm a partner at Gandhi Law Associates. I would firstly like to congratulate MCIA on organizing this event so well. We have attended the sessions yesterday and they were fantastic on such different topics. We got views of different panelists, and I congratulate MCIA for this. The topic that we have for our discussion today is guerrilla tactics in arbitration. We see these tactics, or maybe we call them tactics right now, but they're possibly strategies when we are discussing them with clients. I talk from a lawyer's perspective. There are strategies to either delay an arbitration or render it infructuous, increase cost of the other side. It could be anything. It is frankly to tire the other side. These are the tactics which are usually employed. These tactics have two potential consequences. One is delay in adjudication of the proceedings, rendering of an award. Second is increase in cost. These tactics, as we see, are employed at every stage of arbitration, from the contracting stage to appointment of an arbitrator, during the arbitration and post-award, till it is enforced and you see the color of money. These tactics are employed and a lot of arbitrations lose their way. I am very happy to have a panel, such a distinguished panel, to discuss a topic which is so intense and which we see every day in front of us. I would quickly introduce the panel, which frankly needs no introduction. Justice Kureshi, on my immediate left, has been a judge at the Gujarat High Court and Bombay High Court. He has been a Chief Justice at Tripura and Rajasthan High Courts. Mr. Ravi Kadam, Senior Advocate and former Advocate General State of Maharashtra. Dr. Rishab Gupta, who is an independent counsel at Bombay and barrister at 20 Essex. Ms. Rashna Mistry, who is a general counsel at Tata Projects. Scheherazade Dubash, who is a senior practice development lawyer, international arbitration at Pinsent Masons LLP. And Mr. Shiv Kaushik, who is a senior vice president at Kalpataru Projects International Limited. We have a panel covering all aspects. These people come from different walks of life. Justice Kureshi may be able to give an arbitrator's point of view on the topic that we discuss. Mr. Kadam and Rishab would be able to give a lawyer's perspective, and we have in-house counsels who will be able to give the client perspective on the issue. I would not take further time and request Justice Kureshi to start. Thank you, sir.
Very good morning, everybody. It's a lovely audience, great panel. You know, I was a judge of the High Court for nearly 18 years, to be precise, 18 years. There is one thing I would like to share which nobody will tell you. They say, when I was a judge, they said there are 3 stages in a judge's career. For the first 5 years, the judge thinks he's always wrong. For the next 5 years, he thinks he's always right. And the last 5 years, he does not care whether he's right or wrong. But I realized after retirement, there is a 4th stage where others don't care whether you are right or wrong. So thank you, Kunal. Thank you, Gandhi Law Associates, for inviting me. Very interesting topic. I'll try to bring in the arbitrator's perspective to this issue. As we all know, my friends, in the year 1990, early 1990s, the Indian economy was opened, integrating into the world economy. Need was felt immediately to bring in arbitration law to keep in pace with such developments. 1940 Act had lost its charm, lost its significance. 1996 Act was framed. And we thought that expansion of trade and industry in India will keep pace, the arbitration law will keep pace with the expansion of trade and industry, because we wanted to provide a robust and an efficient dispute resolution mechanism. While the India's economic growth and story is before all of us, we thought 1996 the arbitration scene has arrived in India. But this expectation of will arrive into the tense of has arrived has been more challenging than what we initially thought. There are many reasons for this. Court delays, of course, are the prime reasons, but guerrilla tactics applied is one of the many major reasons on which I would like to present a few thoughts. It is, therefore, I feel that we should focus on making our domestic arbitration system robust and efficient before we can tell the world that India is prepared for the international arbitration scene. Why guerrilla tactics? See, guerrilla tactics is not a domestic or indigenous issue. It's applied world over. But it has a greater propensity, greater potential to succeed, greater propensity to succeed because of peculiar reasons, court delays being the prime reasons. What are the different aspects of guerrilla tactics? How do we deal with them? And how, as an arbitrator, I try to protect the litigation from that is what I would like to present before all of you. 4 or 5 typical guerrilla tactics which I have encountered are, number 1, ask for endless long adjournments. 2, raise frivolous challenges to the impartiality or the jurisdiction of the arbitrator. 3, seek anti-arbitration injunction by, for example, filing a suit on the same subject matter involving the same people, but throwing in a few more people and then tell the arbitrator that, look, a parallel proceedings is pending, non-signatories are part of that litigation before the civil court, you cannot deal with, and therefore stay your hands off. And lastly, and that's where most nuanced areas arise, is to keep challenging at interim stages. An interim order is passed by the arbitrator, raise a frivolous challenge, invite an order, and challenge it. Take a purely hypothetical situation, sometimes I encounter in real life also, is that a person has invited an order at an interim stage, application is rejected, writ petition is filed because it is not an appealable order. The writ petition is withdrawn, then a challenge is made before the court under section 37. Now, as an arbitrator, I know it's a frivolous challenge. But I have a list in the litigation. I have passed an order. Though my training tells me that no appeal lies and therefore it is a frivolous appeal, When he comes back to me and says that, sir, I have filed an appeal, therefore you do not proceed here till the appeal is decided, what are my options? So these are some of the issues, and as an arbitrator, I very often encounter. What are my tactics for that? And I'm sharing my trade secret, so it's a confidential information. Please do not use against me if you appear as an arbitrator before me. One, make full disclosures. When in doubt, disclose. Don't let anything unknown to the parties so that later on they can say that, look, this element you did not disclose and therefore we do not want to go ahead with you. Most important. Two, it's always possible for an arbitrator with some experience to anticipate trouble. You can see the trajectory where it is going. Be very careful. Don't pass a single order without reasons. Grant adjournment, don't grant adjournment, shorter adjournment, refuse a request. Anything you do, give brief reasons that will protect the order for all times to come. Insofar as the interim challenges and approach to the courts is concerned, I make sure that I do not trap myself by agreeing to wait for the outcome of the proceedings. That can be dangerous. For the simple reason that the courts are so flooded with litigation, particularly when the person approaching the court as a petitioner or as an appellant is not interested in fast-tracking the proceedings, it is possible to consume a lot of time. Even subsection 3 of section 8 has a clear mandate that arbitration should go on irrespective of the pending challenges. So I make it very clear that, look, I passed an order. You may have reasonable time to have it tested, but the arbitration is not going to stop before that. Arbitration is not going to be delayed on account of this. Because if I agree to wait for the outcome of the litigation, that's a death trap for the arbitration. And in the process, as I said, even if I know that the litigation is frivolous, even if I know that the appeal is not maintainable, I cannot say on the record. Because now, one, I'm not called upon to. Two, I cannot show my bias against my own order. Let the court decide it. Court may agree, court may not agree. Most cases may be very clear, some may not be. All therefore I do is give a polite reply that, look, subject to outcome of the pending litigation, let us go on with this. Mostly, no irreversible damage or harm would be done. In any case, any order that I may pass, any proceedings which may happen hereafter, will always be subject to the ultimate challenges and the court order that may be passed. Now, one peculiar aspect is here that Bombay, Delhi have original jurisdictions. And therefore, many challenges go directly to high courts. Other jurisdictions like Gujarat, Rajasthan, other courts, where do not have original jurisdiction in the high courts, the challenges go to the district courts. And that itself sometimes brings in different nuances and different way of dealing with it. But all said and done, as I said, look, we must put our best foot forward. This guerrilla tactics will come in different shades, from being unfair, giving the documents at the last moment, to unethical, not providing the documents, to downright illegal document tampering. But we have to provide for all these things. And just remember one thing. What are the terms we use for this tactics? Guerrilla tactic, holding the siege over the litigation, or the case is falling in no man's land. You know what is common between all three phrases? That they are all wartime phrases. As long as we treat commercial litigation as a war, this is going to go on and this is going to happen. All we can do is try to provide for it, try to protect it, and ensure that the litigation sees the light of the day. Friends, very eminent speakers are waiting. I would not take any further time. In any case, they say the first rule of public speaking is that you stop when people ask, why did he stop? Rather than they start asking, why is he not stopping? बड़े गौर से सुन रहा था ज़माना, हम ही सो गए दास्तां सुनाते सुनाते. Thank you so much.
Thank you so much, Justice Kureshi. It was frankly enlightening for us to hear an arbitrator's point of view on when these tactics go on. As lawyers, we feel whether or not the tribunal is appreciating the difficulty that a lawyer is facing on the other side. But we are very glad to hear your views, sir. Thank you so much for it. I would request Mr. Kadam to now share his views. Thank you, sir.
You know, under the protocol, and Devang knows and his lordship also knows, the most important person, Justice Kureshi here, should speak last. Because if he speaks first, then there's very little that you can say. And therefore, protocol is rightly devised that the senior-most person in the meeting speaks last. It's a tough act to follow, but since it's fallen for me to do so, I will try that. Justice Kureshi started with saying that we had the 1940 Act, which, as he rightly said, had become redundant, outlived its utility, was not in time with what was happening then. In the 90s, we had signed various international protocols, and therefore one of our obligations was to bring in new laws, and the Arbitration Act 1996 was a consequence really of Parliament and government deciding that we need to comply with international obligations and bring in a law which is consistent with the arbitration law internationally. Unfortunately, in the process of doing that, and I think it's now pretty well accepted, that we made a law very fast and hastily brought about the Arbitration Act 1996. The result was that, and we've seen that in the last almost 30 years, almost every section, subsection and subclause, every proviso to every section has been analyzed threadbare, and now analyzed threadbare not just by the High Courts but by the Supreme Court also. Society and business, because these laws are meant mostly for people who are in business, corporate, trade, etc. They don't wait, they are not static, they are very dynamic. And the dynamics of business has changed so dramatically, even from 1940, which was almost 100 years ago, that even the 1996 Act needs a serious relook. And I'm sure Devang must be part of the process in which all this relook is going on. The phrase guerrilla tactics can cut both ways. Justice Kureshi said that guerrilla tactics are by people who want to delay, because that's correct, that's one of the very common understanding of guerrilla tactics, is that you want to delay an arbitration, you don't want the consequences of an award which has been properly brought about to be visited upon you, you don't have the resources or for whatever good or bad reason. But guerrilla tactics can be the other way around also. I did a matter which most of you may know, which was Anupam Mittal's case, in which I thought that, see, Anupam Mittal, I'll tell you the facts, the matter is still at large in NCLAT. So, and in the High Court in DP. Now, Anupam Mittal had a company which had this popular website, give them a chance to get into the company. So Mittal obviously didn't want that. And he filed a 241, 242 operation and mismanagement petition before the NCLT as a first strike, anticipating that they would do. Now the contract between him and the investor had an arbitration clause, had a SIAC arbitration provision. So he went as a first strike. So his first guerrilla tactic, I could say, is to go to the NCLT and say, this is the disputes between me and my investor, are disputes which arise under section 241, 242. They are acting oppressively and therefore restrain them from acting contrary to my understanding of the agreement. India being India, courts being courts, our system being the system it is, he didn't get a hearing immediately, but he served the papers. Within 12 days, the investor moved the Singapore High Court. On the 13th day, he got an injunction or an anti-suit injunction restraining him from proceeding with the matter in the NCLTs. So that was the second guerrilla tactic. So they countered his strike with another strike, restraining him from proceeding with his 241, 242 petition in the NCLT. Vittal, being advised by Bombay lawyers or Indian lawyers, did a third guerrilla tactic. What he did was he went to the Bombay High Court and sought an anti-suit injunction against the order of the Singapore High Court, restraining the enforcement of that order in India. And after some hearing, the single judge of the Bombay High Court granted an injunction. In the meanwhile, he had also appealed the Singapore injunction, which had been dismissed. The Singapore High Court said in appeal that we don't know how long the Bombay High Court will take to decide this interlocutory injunction. We can't wait for it because there it's faster, much faster than here. So they said that the delay that will take place in India, because by the time the IA was filed and it was heard, there was about 7, 8, 9 months delay, which we feel otherwise it's pretty fast, but by international arbitration standards it wasn't. So they said we can't wait. We are therefore going to ask the arbitral tribunal to convene and proceed. So after that order was passed, the Bombay High Court granted an injunction saying that they shouldn't have commented on the Bombay High Court and the way in which matters are heard here, because we have a large volume of cases and we hear matters in turn. Anyway, the anti-suit injunction which had been granted in India, the arbitral tribunal there decided that we are going to proceed with the arbitration. So that was natural, because they said that there's no injunction on the tribunal. There's only an injunction on enforcing the anti-suit injunction in India, as an anti-suit injunction had been granted here. So they said we'll proceed. So then Mittal moved the NCLT in the 241 petition for an injunction on the arbitral tribunal from proceeding. So that was the fourth or fifth guerrilla tactic in the same matter. And he got an injunction from the NCLT Bombay restraining the arbitral tribunal on the evening before at 11 p.m. at night. The order was uploaded. Next day morning in Singapore, it's already, I think, a 2.5 hour time difference, or whatever it is. I think it's 2.5 hours. So the next morning at 10 o'clock, the arbitral tribunal was to convene in Singapore. At night, they uploaded the order staying that tribunal from proceeding with it. The reason for saying this is that guerrilla tactics is a phrase which may have a kind of negative connotation. But sometimes a first strike or even a preemptive strike is necessary to enforce your rights as per your understanding of what your rights are. It's not always that, it's always, if you look at it from the point of view of the investor, the move in India, right from the filing of the 241 petition, because obviously that was filed to preempt the arbitration, was a guerrilla tactic and an unfair one from their point of view. Because they said that these are shareholder disputes, they are not disputes which would be covered by 241, 242 at all. From his point of view, in spite of having filed a 241 petition, within 8 days or 10, 12 days, they got an injunction in Singapore. So that was unfair and a guerrilla tactic and a abuse of process according to him. And then so on and so forth, all these tactics took place. Therefore, my view is, and I think we should consider, is that there are basic guerrilla tactics which are definitely have a negative connotation, as Justice Kureshi rightly said. Frivolous challenges, adjournments sought unnecessarily, the challenges at every interim stage for every direction made, you bring it up to the High Court, single judge, DB, Supreme Court. And there are guerrilla tactics which are like the guerrilla tactics of Shivaji, who was also a guerrilla, but which are positive and take cases forward and lead to proper and greater justice than the guerrilla tactics as we understand them, because if I look at it as something which is stopping what is a contractually agreed process, I appreciate that. But sometimes there may be a case where you feel that this is not the forum where I can agitate my grievance. I have something which falls dehors or outside the arbitration agreement. And if these arbitrators decide the issue, then my rights will be prejudiced. So I'd leave you with this thought that the arbitrators can't wait for the courts to decide. We always say that, and we find in arbitration, that the arbitrators rightly tell us that we'll adjourn your matter for 2 weeks, 4 weeks, or whatever it is. You go and get an injunction, otherwise we are going to proceed. That's the correct approach, and in fact, even courts have said that. I remember the couple of judgments of Justice Gawai, where he said that when an appeal is filed, the court should not proceed for a few days, for a week, 10 days. But if you don't get an injunction, the mere filing of a challenge should not be countenanced, and you must then proceed with the matter. I think that's where we are. The challenges which we are facing today because of various tactics adopted is one aspect, but an overhaul of the act is something which is really required because we are almost 30 years down the line, and 30 years is enough time to come out with a new code altogether. Thank you.
Thank you, Mr. Kadam. We firstly want to thank you for appreciating the kind of efforts that we put in while playing such tactics. Thank you so much, sir. Over to Dr. Rishab Gupta.
Hi. Mr. Kadam said that he had a tough act because he had to follow Justice Kureshi. I have an even tougher act because I have to follow him and Justice Kureshi now. That, and because I'm followed by 2 general counsels who actually are the real victims of these so-called guerrilla tactics, I'll keep my remarks very short. What Kunal asked me to focus on was effectively what happens after the arbitration has ended. So you heard from Justice Kureshi what happens during the course of the arbitration. You heard from Mr. Kadam about anti-suit injunctions, anti-arbitration injunctions. What Kunal asked me to talk about was largely the fact that now you have an arbitration award, what happens thereafter, and what kind of tactics may be relevant there. And just for a second before I get into that, obviously that's the key, isn't it? Because no one is engaging in an arbitration for the love of arbitration. No one is doing it to create jurisprudence. Everyone, and again, with focus on the general counsels here, you're doing it for money. That's what it is ultimately to have that money in your bank. And unfortunately, I feel to some extent there's a lot of focus. The entire Arbitration Act is obviously focused on the process of the arbitration, gets you till the arbitration award, has a few provisions on what might happen to set aside an enforcement. But there's very little focus, generally speaking, in discussions and on jurisprudence as well as to precisely the enforcement stage of the arbitration award. Very often when I was in a law firm, clients would ask, how long does an arbitration take in India? And you can sort of give answers by looking at the Arbitration Act, say, well, it used to take much longer, the Arbitration Act has been amended, now it takes less, statutorily 24 months or whatever. But no one then hazards a guess as to how long it will take to actually get the money, to get the arbitration award enforced, because that takes forever. And frankly, at least in my experience, and I'm conscious that those on the panel have much more experience than me, I have been involved in very few cases where, having won the arbitration award, it has been successfully enforced and the entirety of the arbitration award has in fact been collected on. So that's still a rarity in the Indian context. Of course, Rashna, Shiv, if you have a different view, I'd love to hear on that as well. So that's just one point on that. Just coming to what precisely happens. So you've got your arbitration award. Of course, there's the right to challenge. Now that right is sacrosanct. No one should take it away. But I just want to make one observation on that. Before I started practicing in India, I used to practice abroad, and I see some of my ex-colleagues here. I used to be in the arbitration segment of that law firm. We used to genuinely think that we'll start the arbitration by filing the request for arbitration, we'll finish the arbitration, and that would be the end of it. No one was necessarily thinking that after that there'll be a challenge in the English courts and the New York courts to set aside the arbitration award, and another several years would be spent in courts. Because the assumption was that parties would comply with the arbitration award. Most commercial parties would comply. On the other hand, in the Indian context, unfortunately, the assumption is almost always the opposite, that there will be a set-aside application. And therefore, in that sense, while it's not a guerrilla tactic at all, like the way Mr. Kadam put it, that it's not necessarily something which is wrong, but it is become so much a part of our general way of looking at arbitration law and looking at how court practice is, that we don't question that ultimately arbitration awards are supposed to be complied with, and Section 34 applications are not necessary to be filed each time there's an arbitration award. And of course, things can be done in the context of courts to limit that. So for example, one thing which the Indian court system doesn't really have, on paper it has, but in reality it doesn't, is the cost jurisprudence. In other jurisdictions, one reason why you would not file a frivolous Section 34 is because you're conscious of the cost consequences of that. You file a bad Section 34 equivalent to set-aside application, you lose, you have to pay the other side's actual costs. In the Indian context, that almost never happens. When the Act was amended in 2015, timelines were added for how long Section 34 could take. Those were very quickly, effectively struck down as being considered directory and not mandatory. So that's one part of it that unfortunately, it's not really a guerrilla tactic as much from the party standpoint, but something which, at least from a legislative standpoint and from a court standpoint, perhaps could be looked into further to discourage the practice of assuming that every time you lose an arbitration, a Section 34 must follow. Yeah? So that's just point number one. Point number two is, of course, for good mercy, after the amendments, the law that existed prior, which was that the filing of the 34 itself would lead to stay on execution, that has been changed. And of course, the practice, and a very helpful practice, of award debtors having to deposit monies in the court has developed. But again, and happy to hear if you have any views on that. At least in my experience as a counsel, I haven't seen that necessarily work very well each time. Monies may or may not get deposited. They may or may not be satisfactory in terms of the amounts. And of course, money in the court is not money in your pocket, right? So whether or not you're able to then withdraw it from the court, how long it would take, what interest it would carry, what kind of security needs to be provided, those questions are still at large. And a lot of litigation tends to happen around those what may appear trivial, what may appear to be subsidiary questions, but tend to be very, very important questions, because those are the questions which would ultimately mean that as opposed to just having a paper award, you have some money in the bank. So that's just the second point. The third point is, of course, that even after you've gone through this entire route of setting aside the arbitration award, which may involve going to the single judge, the division bench, the Supreme Court, spend several years in courts, and you now have the arbitration award, which has gone through the entire challenge procedure, and you've been successful, you should at that point hope and assume that you'll get money. But you may not get it at that point as well, because that's when the real execution starts. And by then, the award debtor has had at least 7-8 years of having litigated against you, knowing that he or she may potentially lose, and therefore having made himself judgment-proof. By judgment-proof, I basically mean having moved his or her assets out in such a way that you can't easily attach them. And that's where, of course, the real Guerrilla tactics of the award debtors come in. Now, there's not enough time to talk about that. That could be a separate session altogether. But at least from my experience, what I've seen parties do more effectively, and increasingly I think that's happening more so than in the past, is to start thinking about those things well in advance. So, for example, at least in large value disputes, it's not uncommon for parties to engage asset tracers very early on in the process to map out what the assets of the award debtor are. To then look further and see that if there are movement in those assets while the set-aside petition is pending, make applications to injunct that. Our courts typically don't give worldwide freezing orders, but for example, English courts do. Our courts also tend to not be that helpful when it comes to the discovery process, but if you see the US courts, it's very common to get third-party subpoenas, it's common to get 1782 applications, and so on and so forth. So that's the other part that, ultimately from the award debtors side, unfortunately, the system allows a lot of different avenues to delay enforcement and potentially escape enforcement altogether. And for a party, especially a party that's well-resourced, there are ways in which you can try and address it, and there are, of course, lots of different tools available to try and do that. I think I'll stop here because, there's a Q&A session that follows as well. But thank you very much.
Thank you, Rishab. Rashna, please share your views.
And I have even a tougher task after 3 eminent panelists, but I'll give it a shot. So I'll give a perspective from the in-house general counsel on the topic of the government's tactics in relation to arbitrations in India. What I say comes with all the disclaimer clauses, which are deemed to have been read and accepted by each and every one of you. So with this happy note, I shall say that as we all know, government is the biggest litigator in India. It generally never pays under the contract or under the service that is provided to the government. And the client, that is the in-house GC, has to advise on invoking the arbitration clause under the contract, which generally is not institutionalized, and it's an ad hoc arbitration. So our first step would be to give the invocation notice of the arbitration, where we appoint the arbitrator, and we have to just sit tight and wait for 30 days for them to appoint. Good luck if they appoint. If they don't, then we have to move Section 11, go to court and seek the appointment. Depends which court you go. If it's a good court, you'll get it in 6 months to a year. Otherwise, good luck. And as a GC, we have to explain that to our in-house team, the MD, the board, and it is a tough task for us. So luckily, in a year or so, the arbitrators get appointed, and the two arbitrators decide on the presiding. Then the fun begins, where the arbitration proceedings start, if they ever start. Because then the government has to file its statement of defense, which keeps increasing adjournments, different tactics to delay. And finally, when they file, it is quite an amazing piece of art which we have to decipher and break down. Ultimately, the intention of the government is never to pay. So instead of filing a defense, they also generally file a counterclaim, which may be 3 or 4 times our claim amount, to frustrate and try and show that, you were the bad guys, and in fact, I am the one who suffered. So instead of fighting our claim, we are also defending a counterclaim. So that adds to the GC's problems of a double whammy, and explain this to the board, the MD. So at the second stage, again, we face this. Also, they keep asking us on costs, legal costs, and timelines. We do try and give guesstimates or estimates, and we put the word best estimates, which keeps moving with time and with senior counsels or expert witnesses, or trying to defend the counterclaims and things like that. Now, once the proceedings stage is over, the fun begins, waiting for the award. If it's within the time, good luck, but generally it's not within the time, and both parties mutually have to approach court for extension of time by 6 months, which again requires another extension, because sorry to say, arbitrators do take time after such a long proceeding stage, that they need to recollect and write down the award. So happily we get the award after, say, 3-4 years. I mean, I heard Rishab saying 7, but I don't want to be mean by saying 7. So let's say 5 years. My budgets have gone for a toss. My timelines have gone for a toss. Now I get the award, which is just a paper decree. 99% of the time, we don't get our money. I mean, we don't see the light in the tunnel. I would say money in the tunnel. We have to file the execution petition. For that, again, we have to wait for 3 months and try and negotiate and settle, go to the government and say, let's settle, For every 100, they would offer us 10 cents or, 20 cents, which is unacceptable because, we've expended so much time, money, effort, and we want to see at least 50 to 60% of that award amount. But of course, government can never settle, and hence again, it goes into the execution petition. As soon as we file the execution petition, Section 34 is filed by the government, invariably, whether they are strong or weak. Sorry to say, but courts tend to club the execution petition and the Section 34 and have the hearings in Section 34, rather than, hearing the execution. If there's no stay, deposit money, withdraw. I've only had one instance in the Bombay High Court where it deposited the full money and I was allowed to withdraw full money. Other than that, if the client, that is a government client, gets covered under the Niti Aayog circular, they pay 75% upfront and the balance is after the appeal stage. So Section 34 in court may take any number of years. I have no guesses for that. So then I go back to my board and MD and have no time estimates, or whatever time estimates I give may shift either early or later. Then comes our government making statements that, India is the place for investment, all the foreign people come to India, invest, and look at our arbitration, we are improving. Then in June comes a notification or sort of guideline to the government, don't do arbitration. Go for arbitration if the claim is below 10 crore. If it's above, don't go. Go to court or do mediation. How is government going to mediate and settle when it can't settle even on an award? So in short, they don't want the arbitration. They want us to be frustrated, go to court. And as we all know, court, I don't think we will see it in our lifetime. I may retire before any case gets resolved. So on this happy note, I will end and pass it on to the next panelist. Thank you.
Thank you so much, Rashna. We understand it is difficult for you to respond to the board. It is equally difficult for us to respond to you a day prior. Over to Scheherazade Dubash. Thank you.
Good morning, everyone. Since each of my co-panelists are vying for who's got the most difficult job today, I think it's fair to say that it's probably me, because we're talking about a panel that's discussing guerrilla tactics in Indian arbitration, which is appropriate since it's India ADR week. And I'm not going to touch upon anything Indian whatsoever. But let's not lose all hope. We are in a conference where we're meant to be exchanging ideas, and we're certainly seeing a movement in terms of Indian arbitration. And so I think one of the beginning thoughts that I have is to say that when it comes to the imagination of parties and litigants who want to be innovative or difficult, they are universal, whether they're in India or elsewhere. But let's be somber for a moment and think about the purpose of international arbitration. It's meant to be efficient, if not cost efficient. And guerrilla tactics have the opposite impact on both time and cost efficiencies in arbitration. So what I wanted to begin with really is by talking about, in the international sense, some of the reasons why we see this from the party representatives. So let's remember that in an international arbitration, your party representatives on both sides are rarely going to be from the same jurisdiction. You may have one that is from a civil law jurisdiction, say an Egyptian or a Parisian practitioner, who will have a very different understanding on rules of preserving evidence than the counterparty or their counsel on the other side, who may be from a common law jurisdiction. And again, within common law jurisdictions, using, say, for example, the UK and the US, for example, there will be differences in terms of what is acceptable in terms of preparing witnesses for an arbitration. To add to that complexity, there is no universal code of conduct or bar rules or solicitor regulatory rules that prevent counsel in international arbitrations from not partaking in guerrilla tactics on account of the client. So let's see what the users of arbitration are saying internationally, and we have two users on our panel today. But I really like data as a means of letting us know what people are saying, and data is often best collated through surveys. And bear with me a minute, because there is a very well-known university called the Queen Mary University of London, which is well regarded for its international arbitration curriculum. And one of the things it does outside of teaching budding arbitration lawyers is that it carries out surveys where the respondents to it are users of arbitration, and asks them what they are considering to be the biggest downfalls and how they would like to see that change. And consistently in 2018, in 2019, and in 2021, for different surveys carried out on different parts of international arbitration, that same university found some staggering results from their users, all of which said that essentially the lack of robust sanctions being exercised by the tribunal was perhaps one of the weakest parts of international arbitration. And if they were to see anything change in various arbitral rules of institutions, it was to give more case management powers to the tribunal, including robust sanction powers, to combat party tactics and behavior that are essentially guerrilla tactics. So what does this say? This says the obvious, in that users, apart from the one on the other side that wants to obstruct or sabotage an arbitration, really want it to be an efficient process, and are giving that duty to institutions and to what I like to call the guardians of the arbitration proceedings, which are the arbitrators. So what are the arbitrators doing about it? So in international arbitrations, there are various rules, soft guidelines, and national legislation that govern the powers of an arbitrator, or the discretionary powers of an arbitrator. In terms of soft guidelines, they're obviously not mandatory, and they can be incorporated by reference in the arbitration agreement or thereafter by the parties. And the IBA are a very good example of them, because they have various guidelines. So they have guidelines on party representation, they have guidelines on taking on evidence, and each of those guidelines addresses essentially guerrilla tactics and the fact that they should be avoided. And if they aren't avoided, then that should be taken into consideration by the tribunal as the conduct of the parties, which will have cost implications. The CIARB guidelines, or rather the Chartered Institute of Arbitrators, has similar ones. But then let's turn to the rules. Some of the most famous international arbitration rules, the most robust of which on this point is the LCIA's 2020 rules, includes provisions to this effect. And I'll read out what Rule 14 says, or maybe I won't, just to save you and in the interest of time. But essentially it says that on the conduct of proceedings, arbitral tribunals are given wide discretionary powers to ensure that proceedings are efficient and expeditious, and it places an explicit duty on parties to act in good faith for fair, efficient, and expeditious conduct of the arbitration. The ICC rules say something similar, and the SIAC rules are a bit softer in their approach, but they do give tribunals the discretion to take into account a conduct when apportioning costs. But I was also very pleased to see that the MCIA draft rules of 2024 include similar provisions. And they include a robust framework to ensure efficiency of proceedings is not compromised, and empower the tribunal to impose sanctions as it deems appropriate. So I started off by saying I'm not going to be talking about anything India related, but here we are. And that's draft rule 27.7 for those who are interested. So now we know that arbitrators have the discretionary power to control or to resist guerrilla tactics by parties and their representatives. But how is that power exercised, or how should it be exercised? So arbitrators have a very difficult duty of balancing the efficiency of an arbitration proceeding and also the due process and effectively party autonomy. So one of the things that I've seen in arbitrations that I've been involved in are where the arbitrators are bold enough to say from the very outset, and by the outset I mean the case management conference or the preliminary conference, that this is the conduct that's going to be expected of the parties, and to say that if it's not adhered by, then they intend on using the discretionary power that they have been given by the rules and by national legislation or the law of the seat to essentially exercise their power to impose cost awards or interim cost awards. Because let's not forget, arbitral rules also give them, or some arbitrals also rules give them the power to issue cost awards at any stage of the proceedings, and not only towards the end. So I find that quite interesting. the other thing to bear in mind is it's not enough, obviously, to just say that to the parties. It needs to be documented, and the way it's documented is in your procedural order number 1. So these are some very basic but effective ways that tribunals essentially relay to parties and their representatives what they expect and what they won't tolerate. I'll end really by talking very briefly about how courts can help. And I talked about what tribunals can do and what arbitrators can do. But courts have a very important duty as well, especially when they're, and we talked about anti-suit injunctions earlier on in this panel. There was a very interesting case that came, or 3 cases that came before the English courts, where essentially it arose out of an agreement that was entered into between Ruschem and Linde for an EPC contract. And Linde suspended work because of the Russian invasion of Ukraine and said it can't continue. And so Ruschem then called upon the performance on demand bonds. And the 3 banks refused to pay because they said they are unable to pay because of the sanctions. So Ruschem then, despite there being an arbitration agreement in each of those bonds, went to the Russian courts for relief. And of course, the Russian courts have jurisdiction according to a piece of legislation that came out after the sanctions were imposed. The English courts were not the seat of arbitration. The seat of arbitration was Paris, but the governing law of those bonds was English law. And so the English courts, taking that into consideration, thought that they do have the necessary jurisdiction to prevent those Russian proceedings from continuing, because otherwise justice will not be served. So I will stop there just for you to think about the extent that tribunals and courts can exercise their jurisdiction and their discretion to ensure that arbitration remains effective. Thank you very much.
Thank you, Scheherazade. Mr. Kaushik, I request you to share your views now.
Yeah, good morning, everyone. And I thank Gandhi Law Associates and Mumbai International Center for organizing this event and having this august panel, which has already shared their views, and not much is left to say. But being from the claimant side, I always have something to add, always, and to make a new claim. From my experience, I like to share how the guerrilla tactics have been faced by concession companies or contracting companies or the claimant as such, and how they have also evolved, clients have also evolved to sharpen their tactics. So I'll start by, as Kunal has said, that they start from the very inception of the contract only. So in the inception of contract, they put clauses like arbiter has to be appointed by the MD of the company. They put a clauses like the decision of the engineer shall be final and binding. But with the passage of time, judgments have come, Parkinson, and also clients have realized that this is not going to work. Then they came up with a no-claim certificate. Once you are signing the final bill, either you sign the no-claim certificate or you will not get the money. And that also has been overcome subsequently because courts held this is under duress and all that. Now, latest tactics that we are yet to find a solution to that is the very latest one. I'll share with this forum. One of the PSU, what they have started is that they appoint a conciliator unilaterally, and he's a conciliator. Now, both of you are sitting here. He'll pass a conciliatory award under these terms. So that is a new tactic that we are yet to find a solution to that, and certainly we'll see how we can find a solution. But there's always pressure from the client on the claimant that we should not pursue the arbitration. And even if we pursue the arbitration, already the panel members have shared. I'd just like to add 2-3 more points to that. One point is that when I started lodging claims and participating in the arbitration, the concept of leading evidence by way of witnesses was very less prevalent. So CPC was not applicable. People were very much relying on the documentary proof, and parties have exchanged the correspondence at the material time. So that is the basis of coming to a conclusion based on the arguments by the parties. But now, mandatorily, it has become practice that evidence has to be led. And unfortunately, sometimes it takes a very long time to conclude the evidence. There's no end to that. There's no procedure set for that. And arbitrators are also sometimes helpless to control the counsels. I can share in few of the arbitrations, the questions have exceeded 500, 700. Keep on asking the question, 20 hearings have passed. Like that, it's a really pain to the claimant because he wants to see the end of the litigation, but that is always adding to this. Second topic already, Justice Kureshi has said in the very initial part that filing frivolous applications and saying that this jurisdiction is not there under 16 or 14, taking into the court. So I will not touch on that. But another tactics which is that they file documents at any stage of the arbitration. The pleadings have been filed, cross-examination going on. They come up with a bunch of documents along with the witness. So these documents are also to be taken on record. Even at the arguments have concluded, written submission getting filed. At that point in time, they bring additional documents. The tribunal may please hear us again. So it is never ending. So these kind of procedural issues, already my earlier colleague has touched the procedural part that has yet to evolve in India. I think the solution can be the institutional arbitration, wherein strict rules are framed for parties to conduct themselves. Unlike the ad hoc arbitration, where arbitrators are also sometimes constrained to enforce their will, and they are also sometimes helpless, we find that in ad hoc arbitration. If it's an institutional arbitration bound by certain procedural rules based on the international standards, I think certainly will make a long way to have a very fruitful arbitration, and the guerrilla tactics also can be then managed in a much better way. I conclude my here only. So thanks, Kunal. Hello, everyone. Thank you very much.
Thank you, everyone.
Absolutely. We don't really have time for the question answer session, but just 2 or 3 questions that I had and then something from the audience very quickly. First to Justice Kureshi. Sir, these frivolous applications being filed and taking time, of course, at every stage, every order being appealed. Could costs act as a deterrent even at the arbitration stage? Rejecting Section 16 now, Rishab was saying that 34 is a normal phenomenon in India. Every arbitral award turns into a 34. We are often seeing now that there is always a Section 16 in arbitration. So is cost going to act as a deterrent from the arbitrator while rejecting a 16? So this has consumed a lot of time. What usually happens is, I file a Section 17 for interim measures. There is immediately a Section 16 from the other side with a request that the position is settled that unless there is jurisdiction, tribunal can proceed with interim hearings. So this completely derails the Section 17 hearing. Could cost act as a deterrent really, sir?
Kunal, cost is a slightly tricky part, okay? Because at the interim stage, I have to be very clear that it was a frivolous application. Rejecting application is one part. Holding it on record that it was frivolous is another part, right? And second element is that unless I'm very, very clear, even in the final stage, that the defense was frivolous and that he has delayed the proceedings, heavy costs can be an impediment in a weaker party to defend properly. All right, so cost, yes, can be imposed, cost can be considered, but I'm not in favor of heavy costs just to demoralize or to stop challenges. But at an appropriate stage, if I come to the conclusion that it's clearly a frivolous approach to derail the proceedings, probably cost could be one of the grounds.
Thank you so much, sir. One follow-up question, sir, and this is to the entire panel. Should there be a limit on the number of extensions that can be granted by a court to an arbitrator to pass an award? Parties can only grant 6 months, but then there is an endless.
Absolutely agree, but it becomes very difficult to object because it has to be mutual consent. And if I don't accept, the mandate of the tribunal expires.
And you start again.
So might as well you just take the pain and bite the bullet and accept and carry on with it. Sorry to say, but that's, how we
You have
have to live
expressed your
with it.
agony really well. And one last question, sir. We've seen this position being developed with the judgment of the Supreme Court in 2018 in the Duro Fulgera case that if there are separate agreements, separate arbitration references will have to be made. We are now seeing that even in regular course of business, even in purchase orders, there are arbitration clauses. Now, two parties are dealing, there are 10 purchase orders exchanged between them, and there are 10 disputes therefore, essentially a single dispute of non-payment or of quality of product. But should there be 10 references, what it does is, firstly there will be 10 statement of claim, 10 defenses, 10 awards essentially, and it multiplies the cost. Should this require reconsideration if the disputes are identical?
You need a statutory power because the arbitrators can't do it. So only a court can do it. So if you have a statutory provision for clubbing of or consolidating multiple disputes between the same parties into one, the court has a power to consolidate claims into one suit,
Into a single
or
claim.
to break up one suit into multiple suits. Similar power, if you give to a court qua arbitration, it might make a...
Thank you so much, sir. Thank you.
Kunal, just one thing I'll add to what Mr. Kadam said. Or alternatively, do institutional arbitration. Because the institute always has the ability to do it, and through the arbitration tribunal would have the power to do it. One problem that we also have in the Indian context is that we do too much ad hoc arbitration. Which then means that lots of those additional innovations which come through institutional rules are not available. So, Mr. Kadam's point that the Arbitration Act has not been amended for so long. Some of the need for that amendment goes down if you have institutional arbitration, because the institutions are, like the MCI, for example, are updating their rules on a regular basis.
Thank you so much, Rishab. Are there any questions from the audience? Yeah. Please.
I'm Sushil Shankar. A point that I wanted to make was that guerrilla tactics are possible only where the system allows it. And so where it is dissuaded, like if some of you might be knowing that in the SIAC, just to challenge the tribunal, you have to pay upfront a fee of $8,000, which makes parties think twice before they do it. And coming to the Indian context, it sometimes appears that the courts themselves believe that all is fair in love and war and arbitration. And what I have in mind here is there are certain sections of the Indian Arbitration Act which are non-appealable under 37.
Right.
And there are creative parties that bypass this by going in for writ jurisdiction. So for example, I got a Section 8 petition which was allowed, and we were happy that we got it, and we were getting ready for arbitration, and then the other side very creatively filed a writ, and 1 year later the arbitration is not yet even commenced. So this is one guerrilla tactic that I've seen. What do you have to say about this, and is there any solution for this? The court shouldn't have allowed it, but they have.
Yeah, I mean, typically, at least in my experience, writs won't lie against these kinds of things.
They've been
And to the
dissuaded.
extent they have been allowed, they're generally discouraged for such things. I don't know what the specific facts of your case were. But the short point should be that writs for these kinds of things should not be permitted. Yeah.
Should not, I agree, but it has. And it was a very well-reasoned order also.
No, it should not ideally happen. Yeah.
If you see the trend of the Indian Supreme Court, NN Global 3, Cox and Kings 1, and now Cox and Kings 2, they are leaving more and more things to the arbitrators. So there is a huge shift, pro-arbitration approach Indian courts are expecting. But then there are cases and cases, and courts and courts.
Yeah. No, I won't name the High Court, but it's one of the High Courts, yeah.
Thank you so much. Anyone else? Yes, please, ma'am.
So we have 15 minutes for it to become afternoon. So good morning, everybody. Respected panel members, I'm Aditi Prasad. I'm HOD Research at IIL Indore. And being a student of Queen Mary University of London International Arbitration Service, are of my primordial interest because I'm currently doing my PhD on MSME dispute resolution. So my question is to Ms. S. Dubash. I'm sorry for my limited understanding, ma'am. I could not pronounce your first name. So you talked about 2018 survey and 2021 survey. 2018 survey, which was conducted by Paul Friedland and Stavros, Professor Berklikis, he was my professor over there. It's more focused on the evolution of international commercial arbitration as a practice. And it talks more about the dispute resolution policy that the nations should have in order to achieve tactical advantage with respect to seat. And unfortunately, India is the least preferred seat as per the 2018 survey. When we come and talk about 2021 survey, which was conducted by Maria Fano and again Professor Mistelis, they talked about the new nuances post the pandemic inflection, which can be espoused in international commercial arbitration. Now, yesterday, while attending the Tribunal Secretary program, I came across admissibility, relevance, weight, and materiality. I have only one question. What could be the plausible difference in relevance and materiality which may tend to procrastinate the arbitral proceedings explicitly in the name of confidentiality, which is twofold. A, with public at large, and B, with the claims to the opposite party.
Scheherazade, though it's an elaborate question, Neeti is constantly signaling me we are out of time. Please keep it short. Thank you.
Well, I'm going to keep it very short, in fact, because I think it
Sure,
is a very interesting question. But I think the point is, I'm unable to answer your question, one, because a survey deals with various number of questions that go to a large pool of respondents. And when we're talking about statistics, we're talking about what percentage of those respondents are the users of arbitration. So we have to restrict ourselves to understanding, in the context of what I was talking about, it's the end client, it's the users we're talking about, the inefficiencies. Confidentiality is a completely different. I think it's a longer conversation for the networking break, in the interest of time.
Thank you so much.
We're very happy to take it up with you after.
Thank you. I would just like to thank all my panel members. Thank you so much for coming. We had a very good session here. Thank you so much.